Good afternoon, everyone. Good afternoon, Ms. Bridgewater.
Good afternoon, Your Honor.
When is the SAP reset date?
April the 20th.
Okay, thank you.
Mhm.
All right, courtroom 2, it's right at 2 o'clock. We're ready to begin I guess we're ready to begin if you are. Just let me advise everyone that if you're on Zoom, that you are to conduct yourselves as if you're actually in court with me. So that means that you need to adhere to all the court procedures that you'd be doing. That includes chewing gum. So if you're eating or chewing gum, please refrain from that while we are in this court session. Thank you.
What? Your Honor, position number 1, Mr. Allen.
Okay, thank you. Good afternoon, Mr. Allen. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, of course.
Thank you, Mr. Allen. You've been charged in case 23 CR 002095A with a fray. Is there a history? Mr. Howard, good afternoon.
Hello. 7 total. 2015 suspended license conviction. 2014 preventing disrupting General Assembly. That was NOD'd and a 2012 trespass dismissed.
Okay.
That's it.
Okay, all right, thank you. Good afternoon, Mr. Agnew.
Good afternoon, Your Honor. This offense date took place yesterday, April 5th, 2023 at 1236 Boat Rock Road, Southwest Atlanta, in Atlanta, Georgia. Officer responded to an assault and nuisance call upon arrival and separation and establishment of the scene. Officer spoke to several witnesses. There they ascertained that a group of citizens were gathered around outside that address protesting a film company due to alleged unfair wages being paid to the film crew employees. And protesters were outside picketing and protesting the film when the victim in this case, Your Honor, there's a co-defendant. This is an affray, obviously. So we have this Mr. Allen and then another defendant, Mr. Benton. Same fact patterns. He is the father of someone who's renting a house at that location, and he went there for what officer described as a checkup on the property. A dispute arose over a sign that was placed in his daughter's yard, and when Mr. Benton took the yard sign out of her yard, a physical altercation took place between Ronald Allen and Delrick Benton. Officers were able to review witness video of the altercation, and in the video, the two men could be seen fighting, wrestling each other. Both parties received substantial physical marks from the altercation, and both were charged with battery. Our office has elected to charge these cases as a fray. Like as pretrial has stated, I believe he only has those arrests involving protesting and interrupting lawful meetings. The state's recommendation in this case for the one count of a fray is a $2,000 surety bond to stay away from the incident location, that 1236 Boat Rock Road, and to have no further contact with the victim, the co-defendant, Mr. Delrick Benton.
Whose address is the Boatwright Road address?
That is Delrick Benton's daughter's address.
Okay, all right.
Yes, Your Honor.
Yes, Miss Wills, is this your case?
Good afternoon.
Good afternoon.
Mr. Allen is 46 years old and he is employed by the Art Directors Guild. He's an organizer. So he was there leading a strike. He states that he was assaulted by Mr. Benton, that he did not initiate the physical confrontation between himself and Mr. Benton, that the entire incident was caught on video or captured on video, and he adamantly denies starting the incident and the physical conduct or contact. He was at work and he was leading a strike. Mr. Allen has a master's degree in finance. As it was stated, his last offense was a driving offense approximately 8 years ago. So we are requesting a signature bond in the amount of $2,000. We have no objection to Mr. Allen staying away from Mr. Benton. I am unsure about that location. I'm not sure whether Mr. Allen is working there on a film or if it's affiliated with his employment at all, if he has any further business.
Well, if this is Mr. Benton's daughter's address, then I'm not going to have Mr. Allen, regardless, go to Mr. Benton's daughter's address. So I will issue a $2,000 signature bond through the jail. No further contact with Mr. Benton. Stay away from the Boatwright Road address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Allen. Your client has his hand up, Ms. Wells.
Mr. Allen, only if you have a question as it pertains to your bond, nothing about the facts of your case.
I hear you. My privileged record, I was arrested with Senator Warnock at the Georgia State Assembly because the Georgia state government did not extend the Obamacare, which will allow 600,000 more people be covered.
Okay, Mr. Allen.
Just prior record, you mentioned
Okay,
prior record.
I've given you a signature bond, Mr. Allen. So unless you want me to reconsider your signature bond that you getting out, I would advise that you don't continue, and you have a right to remain silent. Anything you say can be used against you. So I suggest that you take your lawyer up on remaining silent at this point in time. You've gotten a signature bond and you'll be able to come back and defend yourself at some later time. Good luck to you, Mr. Allen. Do we have Mr. Benton there also?
Sure, we do, Your Honor.
We gotta take him out first, Your Honor, for safety.
Okay, I understand.
Ms. Allen.
Your Honor, position number 2, Mr. Benton.
Okay, thank you. Good afternoon, Mr. Benton. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Courtroom 2, you're on mute.
Yes, sir, I do. Good afternoon.
Oh, thank you. You've been charged in case, good afternoon. You've been charged in case 23 CR 002094A, also with the fray. Is there a history, Mr. Howard?
15 total. 2017 failure to appear. He had a couple of probation violations from 2014. I didn't see any violent conviction.
Okay. And anything to add to the facts, Mr. Agbe?
Your Honor, the facts remain basically the same. The state does have some concerns because on Mr. Benton's record, we did see several failures to appears and probation violations. So the state does have a concern about his responsiveness to the legal process and legal orders. Your Honor, in light of that, with the facts that have been laid out about the affray with the co-defendant, the state's recommendation in this case is also a $2,000 surety bond to have no further contact with the victim and no alcohol, drugs, or weapons while out on bond. Obviously, this is the address for his daughter, so we would be asking for a stay away provision, but just no further contact with Mr. Allen.
Okay. Good afternoon, Ms. McLeod. Is this your case?
It is, Your Honor. Good afternoon.
I'm
My-
gonna give him the same bond, the signature bond, if there's no objection from you.
I have
or
no
to-
objection to that, Your Honor, but I would like to put on the record that this
Okay.
property is owned by my client's daughter, who happened to be out of town and asked her dad to go and check on the property. The property is frequently rented by film companies and is currently being rented by a film company for a film. And my client just went there and there were some signs actually on the property, which he removed, and that was when he was attacked by the other gentleman.
Okay, so it's also gonna be a $2,000 signature bond through the jail, no further contact with Mr. Allen, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Benton.
Thank you, Your Honor.
You're welcome.
Your Honor, position number 4, Ms. Gilmore.
And I would request a breakout room for Miss Gilmore.
Okay, are we gonna need any other breakout rooms this afternoon? I'll take it since I didn't have a response.
Yes, I do, actually. There's one more that I need to request a breakout room, Your Honor. It is for Price.
Okay, so let's do Mr. Price and Ms. Gilmore at the same time. So everyone that needs to go into the breakout room, so Ms. Allen, Ms. Kim, Mr. Howard, Ms. Bickerstaff, Ms. Wills.
And also Miss Stevens, she is from DFAX.
Okay. And who's presenting on Ms. Kim's case? Do we know? I just want to make sure that everybody's in.
Your Honor, that's going to be Mrs. Bickerstaff.
Okay, very good.
Thank you.
Thank you. All right, so if you put us all into a breakout room, please.
Okay, Judge.
Thank you.
Excuse me, I don't know if the person's still here, but I also need to be in the breakout room. As well as Miss Scott.
Okay, let's see, courtroom two. I appreciate your patience, everyone. We're back. We've had an opportunity to discuss Ms. Gilmore's case. Ms. Gilmore, Mr. Derek Howard is there in the is they're going to be there at the jail, and he's going to speak with you more this afternoon. So we'll either readdress your case today, or we'll readdress it in the very near future. If it's not readdressed today, then then the bond is going to remain the same, and I will speak with you about conditions or modifications in the very near future. But expect a visit from Attorney Derek Howard, okay? Who do we have next?
What was the bond amount?
There's not going to be a modification on today's date unless Mr. Howard's going to be there and he's going to speak with Ms. Gilmore. So she already has a bond that that I,
Okay. I'm
that I
sorry.
issued.
Judge.
Okay, hold on, Ms. Gilmore. You have a right to remain silent, and you're going to be able to talk to Attorney Howard when he gets there. So, and he'll be able to talk to talk to me. Okay. So I don't want you to say anything that's going to get you in trouble. But we're trying to figure out, how we can best help you. Okay. So we'll be back with you, and if we're not back with you today, we'll be back with you very soon. Okay, this case will be reset to the latest Monday.
Position
Okay.
number 8, Your Honor. Ms. Price.
You okay, Brian? Okay. I'm not feeling okay.
Oh, and this is Sharika Price. Is that right? No. Yes.
Yes.
Okay. We have had the opportunity to discuss your case also with the attorney. Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. It's my understanding that Ms. Price's mother is on the line. Is that correct?
Yes, Your Honor. I just saw her name.
Okay, I see that she's coming in.
Yes.
Let's see, Ms. Price, good afternoon. I'm Judge Eric Morrow. Can you hear me? Ms. Price? Is she still there? Ms. Price, are you with us? I'm not sure if she is or not. Courtroom 2 for we had the opportunity to discuss your case in a breakout room with your lawyer and with the state. I'm going to give you a signature bond. Okay, so it's going to be a $2,000 signature bond through the jail. But can you unmute for me, courtroom 2? Because I want to make sure that, but it's my understanding that you're going to be staying with your mother. So I'm going to, okay, I'm going to order that you stay with your mother. That's why I wanted to talk to her. But also, you understand, Ms. Price, you cannot go back to this red carpet liquor. You understand that?
Yes, sir.
Okay, so I'm going to let you out.
Yes, thank you.
Okay, and if you don't come back for your next hearing, you're going to get another hearing date. Make sure to show up, because if you don't show up, then they're going to put a bench warrant out for you. You're going to be right back where you are. You understand me?
Yes.
Okay, so all right, so you're going to get out today, but don't go back to that liquor store, okay? Okay, good luck to you, Ms. Price.
Getting out.
Your Honor, position number 9, Jerome.
Okay. Good afternoon. This is Ms. Ross. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Okay. Ms. Ross, you've been charged in case 23 CR 002092G with battery family violence. Is there a history, Mr. Howard?
No.
Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred yesterday at about 8:20 in the evening at 1371 Kimberly Way Southwest. And this is where officers arrived at the location for the second time that day in response to an altercation between the defendant and her mother, I'm sorry if I mispronounced your first name, Rekia, and that's spelled Reika, Wright Parks. Ms. Parks stated to the officers that they were in a verbal dispute. Then the defendant punched her in the eye, causing her eye to be bruised, causing a black eye, Your Honor. And a neighbor named Miss Alexis Grove told officers that she observed the defendant punch her mother, Your Honor. For these reasons, the state's recommendation is a $3,000 surety bond, 1-day anger awareness, no further contact with her mother, Ms. Rekia Wright Parks, and to stay away from the 1371 Kimberly Way address and a one-time police escort for her belongings, Your Honor. And I see Ms. Wright is on the Zoom call, so I would like to sound for her.
Yes, well, I see you there also, Ms. Wright. This is your opportunity to address the court if you choose to do so. If you would like to address the court, I'll need for you to raise your right hand and I'm going to have to swear you in, okay? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Ms. Wright. What would you like to tell the court?
Well, my daughter doesn't have anywhere to go. And when I talked to someone earlier, they said that it'll just be no violent contact because she also have my grandchild.
Okay,
So,
so let me ask you this, Ms. Wright. Does your daughter live with you?
Yes.
Are you afraid of her?
No.
Has this happened before?
Yes.
Okay. So it's you know, it sounds like that you're having some problems with your daughter, and I am reticent to put her back into the household, given that, you know, although you did say that you weren't afraid of her, it seems to me that anytime that the police come out and there's an altercation of that nature, that I need to be concerned about not only you, but also, you know, others that are in that household. So anything else that you like for me to tell me?
Well, I just lost my oldest daughter, which is her sibling,
Oh,
Valentine's Day, and we are going through a lot right now, and we just trying to, you know, grieve and put everything together.
okay.
So, and we're in the process of getting evicted and a lot of more stuff, house issues, and you know, I'm in the
Okay.
process of moving and stuff. So I understand, you know, we both got
Mhm.
situations going on and trying to handle it the best way we can.
I
And we really
understand.
all we got.
Okay. And she's only 17, is that right?
Yeah, she just turned 17. She have my grandson, which is 1.
Okay. All right. I appreciate it, Ms. Wright. Sorry that you're going through what you're going through. Ms. McLeod, is this your case?
It is, Your Honor.
Okay.
My client is in fact 17 years old. She tells me that she's trying to work on her GED. She is a mother of a 1-year-old little boy, and she tells me that, you know, her focus now is on taking the best possible care she can of this child. And she tells me that the issue started because her mom had called her to come and get her child, and she had gone there, and, you know, her mom started arguing with her while she was taking care of her child, and it escalated. She also did mention the fact that she lost her older sister and that both of them are grieving, and she thinks that this has impacted their relationship. She really doesn't have anywhere else to go with her child right now, although she's trying to get somewhere to go. She is working, actually. She tells me that she has been working at McDonald's and trying to get her life together so she can provide for herself and her son. Your Honor, I have spoken to Mom earlier, and she told me that she would prefer no further violent contact. And this would enable my client to go back there, and she really does plan to move out, but she just cannot do it right now, Your Honor. She needs a few months to get her life together. So I would ask the court to consider giving her a signature bonds so she can get out of jail, and to allow her to go back there with no further violent contact between the parties, and give her a chance to get it together so that she can move out.
Okay. Courtroom 2, can you unmute, please? Ms. Ross, let me first say to both you and your mother, I'm sorry for your loss. I know that it's a difficult time for you. Your mother is here on your behalf today, and I am going to allow you to sign yourself out and to give you a $2,000 signature bond through the jail. And I'm also going to, because it's your mother and she is making this request, I'm going to have you have no further violent contact with her. Just know, though, that I'm giving you an opportunity. If you violate this bond condition by having any further violent contact with not only your mom, but with anybody, then this bond is going to be revoked and you're going to be right back where you are. Okay, so know that you're getting the opportunity to do right, and that, you know, I know that you and your mother are going through a lot right now. So know that you're just getting an opportunity. You can have no drugs, no alcohol or weapons while you're out on bond. You understand me?
Yes.
Is that a yes?
Yes.
Okay. Good luck to you, Ms. Ross. You also.
Your Honor, one moment, excuse me. Anna Allen for the state. Is there a medication compliance issue? Could we ask Mrs. Wright if that is something that would assist her, if the court would order the defendant to be medication compliant or to follow through with any DFACS orders or custody orders that are in place?
There are no such
About a
orders.
17-year-old defendant and an infant child and a mother who's just testified reluctantly that she's not afraid of her daughter because she wants her grandchild to be back in her home so she can care for her grandchild. This police report says they've been to the residence multiple times. Our notes from our contact with the victim indicate this violence has been an issue since the defendant was 12 years old, and mom really would need some support at this point. So if the court would be inclined to order medication compliance, if this young woman is on medication or supposed to be, and you know, cooperation with any orders that are in place related to DFACS or custody, that would, I think, maybe assist mom, but we can of course ask her.
Well, to my
and just let me make this clear. In the future, let's not do this on live YouTube, okay? Because I'm not. I don't want this young lady's mental health to be placed on the record that way. So it's difficult for me to ask that question unless we go into a breakout room. So
If
I'm
it's
happy.
appropriate to do that,
Right.
then we can do that. That is not a problem. I was
Right.
just asking if there were any other things we could do to support this mother, because it was obvious to me when she said she wasn't afraid that she was reluctant to say that, and her interest is really about another juvenile in the home, because this defendant is still a juvenile in that sense.
And I do understand that, but I also understand that if Ms. Ross is back on the street, she'd probably have her child with her, and she would not have any placement while she's back on the street with a you know, less than a, she's a minor, and the child's a, you know, is probably no more than a baby. So we do the best that we can do in that regard. Ms. McLeod, are you able to respond to that question without us going into a breakout room as far as if there's any medication that she needs to be compliant with?
I'm not aware of when I talked with my client, this was not raised by her, and she sounds to me like a regular, ordinary, normal, coherent 17-year-old. She's very responsible. She is employed. And I don't really want to go into what her take is on the issues, you know, concerning her mom. The relationship is not exactly an ideal sort of relationship, but she understands that her mom has issues and she's coping with them.
Okay, well, she does understand that if she comes back, that she's not going to get the benefit of the signature bond. And I will say, if she is on any prescribed medication, that she is to remain on that medication, and that will be placed in the order. And as far as DFACS is concerned, I'm not sure if they are involved or not, but if DFACS is involved, then of course you'd have to be compliant with any of the DFACS orders, and that would just not be an order of this court, but I'm sure that would be something that DFACS would maintain also.
DFACS is involved to my understanding. Your Honor, my client tells me that her focus is on her child, and it has always been ever since she has this child. I know that she's young to have had a child, but she tells me that that has centered and focused her, and she makes him a priority.
Okay. Okay, well, thank you. That'll be the order of the court as far as the bond goes. I know, Ms. Wright, Ms. Ross, you have your hand up there, but know that you have a right to remain silent. Anything you say can be used against you. I have given you a signature bond, and I don't want you to talk me out of that. You know, you might, you know, if you want to talk me out of it, I'm happy to listen to you, but I think that you should take Ms. McLeod's advice, and she'll be in touch with you regarding that, okay? All right, if nothing further, good luck to you, Ms. Wright, and you also, Ms. Ross. Who do we have next?
Position number 12, Ms. Torres.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, thank you, Ms. McCombs. The pleasure as always.
Have a good day.
You too.
Thank you.
Good afternoon, Ms. Torres. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? You're on mute, courtroom 2.
Yes, Your Honor.
Okay, thank you. Ms. Torres, you've been charged in case 23 CR 002097F with battery family violence. Is there a history? Mr. Howard?
Second arrest, 2022 FTA and a suspended license to play a NOLO. That's it.
Okay. Yes, Ms. Bickerstaff?
Yes, so this incident occurred yesterday at about 7 p.m. at 10630 Colony Glen Drive in Johns Creek. And this is where officers arrived in response to a dispute between the defendant and her brother, Mr. Fernando Torres. They live at the same residence with one another. And this is where the defendant slapped Mr. Torres in the face, causing redness to his face. The altercation started over the defendant failing to give Mr. Torres the house key. And so she slapped him. Our victim advocate was able to speak to Mr. Torres, and he did let her know that he is not afraid of his sister, Your Honor. But for these reasons, the state recommendation is a $3,000 surety bond, 1-day anger awareness, no further contact with Mr. Fernando Torres, because we want to make sure the adequate cooling off period takes place, and to stay away from 10630 Colony Glen Drive at Johns Creek, and as well as no alcohol, drugs, or weapons while out on bond, and for the defendant to get a one-time police escort to retrieve her belongings, Your Honor. If Mr. Mr. Fernando Torres is on the line, and I would like to sound for him.
Okay, I see him there, and I will address him in turn. Thank you, Ms. Bickerstaff. Ms. Kim, would you like for me to speak with Mr. Torres before your presentation?
Yes, Your Honor.
Okay, good afternoon, Mr. Fernando Torres. Let's see, if I see that you're there, I know that this is your sister. If you would like to address the court, I'll need for you to raise your right hand and I'll have to swear you in. You swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, you can put your hand down, Mr. Torres. What would you like to tell the court?
Well, I had spoken previously, I think, to a public defender. Before that, it was Miss Kim. She had mentioned to me the whole situation. She told me about everything. When I spoke to her, well, let me get my thoughts in order here, because they didn't mention that that she couldn't come back. But I'd mentioned to her, it's okay, she can come back here. I'm obviously gonna have my own space, bottom floor, so it's not a big deal. However, yesterday things altercated a lot, and they escalated to that point. But I mean, she's still my little sister, and there's a lot of things that I'm taking into consideration. But I just wanted to point that out. It's just been a lot of stuff going on in my life as well, but it's it's at the end of the day, it's still my little sister. So I just wanted to let everybody know that, but mostly the court. So in terms of those things, I guess she'll speak to the public defender about that, but I'm not scared of her. She can come here, she can live here. It's totally fine. I understand what the state wants to do. But that's probably not going to work. And then it's going to be a little bit more disputed on that end, but they had mentioned a plea deal or something like that. And but I mean, in terms of everything, I think I just took in all the information. It's 3,000 surety, and I get it, but that's it. That's all I just wanted to let you know. And yeah, I guess.
Okay, so
how do we proceed?
This is just a bond hearing today, Mr. Torres. Anything further will be dealt with down the road. So as far as bond goes, my question to you is, has this happened before with your sister?
No, it's never happened. She's never put her hands on me like that before. That's why I was a little shocked. I had gotten up and I was like, okay. So,
did you call the police?
Yeah, well, I mean, I called and then I hung up and then I was sitting outside. I just didn't know who to talk to. So I was looking for resources. And luckily the officer left me his card and stuff, and I was trying to call. I remember I tried to leave an email like a while back ago, and I had heard no response. So I'll look to different resources so I can just see if I can talk to someone. But that's, in terms of everything, I feel like I've been, just piled on in terms of just where I stand in my, I guess in my stance. It doesn't feel valid sometimes. So, yeah, I didn't know what to do, who to call. And then when I spoke to Miss Kim, I let her know that I apologize for expending resources in such a way. I was just outside. I didn't know who to talk to. I called. They called me back. They said, just stay on the line. Let's just get some officers out there. Let's see what we can do. And then, things were escalating. Valerie had admitted to certain things, but it is what happened yesterday. And my little brother was there.
Is
There's people around.
Is that Diego here on the line?
Yes, that's he.
Okay. And does he live with you all also?
Yes, he lives here. Yep.
And who else lives in that household?
Our mother.
Okay. And is it your mom's house?
No, we're renting. And she's not in town right now. She's in Peru.
Okay. And how old are you all?
I'm 27.
I'm 28.
How's your
Valerie's
sister?
24, I believe. She's a 99 baby.
Okay. And Diego, how old are you?
I'm 27, Your Honor.
Okay. All right. And anything that you want to say, Mr. Diego Torres? If you do, I'll have to swear you in. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. What would you like to tell the court?
Only that, yesterday was just another sort of culmination of a string of incidents that have been occurring since 2017 when our brother was diagnosed with bipolar episodes. And it's just sort of like a sibling thing that shouldn't have ended the way it did. I don't know why Fernando used that resource when he has other resources that he could have reached out to. But here's where we stand. Anyhow, I work from home 2 out of the 5 days of the week, and today I'm in the office. But yesterday kind of, it's one thing to be upset about not having a key. He lent her the key, and it was a failure in communication to where the key ended up. And Fernando just started a new job, and I can't confirm if he's been on his medication or not. We kind of trust him to follow that path.
Mr. Torres, Diego, I don't want you speaking to anyone's mental health on here, okay? You understand me? So I understand that you have some issues with that, but have you had any problems with your sister in the past?
Absolutely not.
First, okay. And you live in that household and you feel comfortable with her being there?
Yes, everyone feels comfortable being there. Like I said, it's just he started a new job and he's mad about his key. He walks to work, walks to and from work, and he just kind of walked into the house kind of, wanting to be confrontational, and I mean that in the sense of just the tone of voice, strictly the tone of voice. So, I'm not trying to talk about, mental health, but this is very much that case, but anyway, so yeah, yeah, that's all I have to say, I guess. Everyone's fine. Everyone in this, us three, our parents got divorced and we got closer because of it. This is should have been an isolated family incident that fell on the hands of the Johns Creek PD, who, did what they could, I guess. But yeah, that's about it, Your Honor. I have other things, but I don't know how much to divulge without it having to do with what one of these people involved go through on a daily basis.
Okay. Ms. Kim?
Yes, Your Honor. Miss Torres is 24 years old. She was born and raised here in Georgia. And Your Honor, she has 2-year-old son who is minor. And they live together at that house. Your Honor, I think she needs to go back home, and she has no other place to go if she does not allowed to go back to 10-3, Kalani Glen Drive, where she resides with her brothers. So we would like to ask you to have a no further violent contact. And also she has a job interview on Monday. So she really needs to get a job so that way she can continue with her dream to become a licensed esthetician. She has already signed up and enrolled in a school for the next 10 months. And she needs to earn money to pay for her tuition and living expenses for her son as well. Thank you. We would like to request for signature on bond. There was no violence in the history. This is her first ever. And she was very honest to the police if you read the warrant. Thank you very much.
Ms. Kim, I'm sorry. I need to ask something real quick. The charge initially, you told me was a misdemeanor, and I don't think it's necessary to go up to battery, but I'm just saying, I would hope it stays a misdemeanor because I don't think a felony charge should be on there.
There's
This is misdemeanor court, Mr. Torres. Your sister's not charged with a felony.
Thank God.
It's
All
gonna
right.
be a $3,000 signature bond through pretrial to monitor per the judge. 1 day anger awareness, no further violent contact with Mr. Torres, and no drugs, alcohol, or weapons while out on bond. Good luck to all of you all.
Thank you, sir.
All right, who do we have next?
$3,000. Pretrial. Yeah, position number 3, Mr. Coleman.
Was that anger awareness?
Yes. Good afternoon, Mr. Coleman. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Coleman, you've been charged in case 23 CR 002096H with battery, family violence, and criminal trespass. Is there a history, Mr. Howard?
Fifth arrest, 2018 suspended license, 2009 failure to appear. That's it.
Yes, Mr. Agnew.
Good afternoon, Your Honor. This offense date took place on October 11th, 2022 at 925 Canterbury Lane, Northeast in Atlanta. Officers responded to a dispute there. They met with the victim in this case, a Mr. Carl Lashley, who said that he arrived at his home and received a knock on his door. Mr. Lashley looked through his peephole and it was covered. And I guess his better judgment, he opened the door. It was at this time that his estranged husband barged into the apartment, into the victim's residency. Mr. Lashley repeatedly asked Mr. Coleman to leave, but he refused. He said immediately Mr. Coleman engaged into a physical altercation with the victim, which resulted in him kicking him several times. Officers observed several bruises onto the victim's body. After the physical altercation, Mr. Coleman apologized and then left before officers were able to make it to the scene. Your Honor, the state has some concerns. We were able to speak to the victim in this case. He's communicated that there has been physical, there's been a physical history between the two, that he would like no contact and to stay away from that location. This is the location of where that the victim resides. I do believe that I saw his name on the call earlier. I believe so. I do see Mr.
Yes,
sir. So we would ask that he have an opportunity to speak as well. But in light of the nature of the offense and with the defendant coming to the victim's home, the state's recommendation in this case for the first count, battery, family violence, is a $2,000 surety on the criminal trespass and $2,000 surety for a total of a $4,000 surety. No further contact with the victim, stay away from the incident location, completion of 1 day of anger awareness, and while out on bond, no alcohol, drugs, or weapons.
Okay, Mr. Lashley, I see you there. If you would like to address the court, I'll need for you to raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, what would you like to tell the court, Mr. Lashley?
Your Honor, I do want to thank you for the opportunity, of course, to speak. I am a bit concerned that maybe there might be some extraordinary hardship placed on Mr. Coleman as a result. It has not already been declared here, but Mr. Coleman is also facing anger management in a different jurisdiction, as well as there is a TPO in place as well. So I just want the court to be aware of that as well. I'm not sure if the court has any additional questions for me. I do know that to speak to Mr. Coleman, while I've had a concern, of course, in the past, I've been able to address some different recourses as a result of the incident, but I'm also aware Mr. Coleman works. He's also in school as well. So I'd like the court to take that into consideration today.
Okay, so Mr. Lashley, this Canterbury Lane address, that's your address.
This is my primary residence. That's correct.
Right, and you're telling me that obviously you want no further contact with him, but there's also a TPO already in place regarding that he was to have no further contact with you. Is that right?
That's correct, and that was obtained subsequently as a result of our encounter.
Okay, so that was after this October incident.
Correct.
Is that right? Okay. All right. All right. Thank you, Mr. Lashley. Ms. Wills.
Mr. Coleman is 37 years old. He is a business owner. He owns Swinky Paws Pet Care. He does not have any prior offenses other than traffic offenses. He reports that he is from Georgia and enrolled in college at Morehouse. Mr. Coleman let me know that he was unaware of the warrant until recently, and he turned himself in. He states that he and Mr. Lashley are in the process of, they are currently separated, and he states that upon his release, he will be initiating divorce proceedings. Mr. Coleman also informed me that he and Mr. Lashley were in communication around the time that this incident took place, that he has witnesses. He adamantly denies the allegations and states that the cause of the altercation between the two of them were that Mr. Lashley had drug paraphernalia in his home that Mr. Coleman was able to see or was going to see, and that's where the altercation ensued. Mr. Coleman also states that the TPO was based on false allegations. However, he has been complying with the anger management classes or the family violence classes. He also is enrolled or engaged in therapy twice per week. So in light of that, we would object or ask that he be allowed to continue those family violence classes that he is already currently enrolled in, as well as his therapy. And we would ask for a signature bond. Mr. Coleman has no desire to maintain or have contact with Mr. Lashley, so we would have no objection to no contact and a stay away order. They do not live together, and he states that they have not had any communication in quite some time.
For the battery, it's going to be a $2,000 signature bond through pretrial per the judge. For the criminal trespass, $1,000 signature bond through pretrial per the judge. Makes it a total of a $3,000 signature bond through pretrial per the judge. No further contact with Mr. Lashley. Stay away from the Canterbury Lane address, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Lashley. Good luck to you also, Mr. Coleman.
Thank you, Mr. Brown.
Thank you, Your Honor.
Your Honor, we have position number 5, Mr. James.
Good afternoon, Mr. James. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? I'll take that. He's nodding. That's a yes?
Yes, sir.
Yes, thank you, Mr. James. You've been charged in case 23 CR 002098F with failure to obey a traffic control device, obstruction of a law enforcement officer, and improper stopping. Is there a history, Mr. Howard?
No, it was a SOB jail recommendation.
Okay. Mr. Agme?
Yes, Your Honor. The state's going to be recommending a signature bond in this The facts that we know it that was incident took place at yesterday, April 5th, 2023 at 4 a.m. in the morning. Officers observed a colored Honda Accord driving through a red light on Cascade Road near the intersection of Cascade and Adams Drive. Officers initiated a traffic stop and made contact with the driver, later identified as Mr. Keyshawn James. When officers inquired as to why he ran the red light and then made an abrupt stop in the middle of the roadway. When officers inquired as to his actions, he stated that he needed to reconnect his cell phone to figure out where he was going. Officers asked him to step out of the car. He refused, and he kept reaching in between his seats. Officers asked him to step outside of his car. He then struggled with the officers when they tried to detain him and arrest him. He slipped out of his handcuffs, and he had to be re-handcuffed. Throughout the whole time, he had to be physically moved, refusing to move on his own. Your Honor, this is the first arrest. The state's recommendation in this case is a $3,000 surety. That's a $3,000 signature bond, $1,000 on each count, and no alcohol, drugs, or weapons while out on bond.
Any objection to any of that, Ms. Wells?
No objection.
It's going to be a $3,000 signature bond through the jail, $1,000 on each offense, no drugs, alcohol, or weapons while out on bond. Excuse me. Good luck to you, Mr. James.
Your Honor, Mr. Kelly, position number 6.
Okay. Good afternoon, Mr. Kelly. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Kelly, you've been charged in case 23CR002093A with theft by taking. Is there a history, Mr. Howard?
It is 12 total. Last arrest was 2019, simple battery against a person who is 65 years or older or pregnant. Let me get that case number for you. And it was aggravated assault. He's on probation for burglary, 12 SC 107442. In 2013, they gave him 2 years of service and 18 years probation for that. I got another ag assault, 14 SC 131471. 2015, June, they gave him 8 years, so that should time out in June of this year. He went to felony first appearance early, I think, for the ag assault. I got a simple battery conviction, failure to appear, 2019. 2018, criminal damage to property, second degree arrest. 2016, probation, and before that was the 2014 ag assault conviction. 2012, 2 counts of ag stalking, 1 count burglary arrest, and a 2011 violation of family violence order. I'll leave it at that.
Mr. Agbe?
Thank you, Your Honor. This offense date took place on July 4th, 2021 at 1720 Marietta Boulevard here in Atlanta, Georgia. The head manager of the Circle K located at that location contacted law enforcement when he was conducting an audit and discovered that there was a shortage of bank funds. As a result, he reviewed his surveillance video. On the video, he observed the employee, Mr. Torres Kelly, taking money out of the register and putting it in his pocket. When Mr. Cunningham tried to contact Mr. Torres about the money, it was at this point he discovered that the number he had for Mr. Torres was no longer working, and Mr. Torres Kelly never returned back to work. The head manager stated that the amount taken was a total of $786 US. Your Honor, the state has some major concerns. Primarily, the defendants appears to have some difficulty following orders of the court. There's several probation violations on his record, also some failure to appear. He also knows where the primary victim in this situation, Mr. Cunningham, works. So with that in mind, the state's recommendation on this count for the theft by taking is a $2,000 surety bond, no further contact with the victim, stay away from that incident location, and while out on bond, to have no alcohol, drugs, or weapons.
Okay. Ms. Wells?
Thank you, Your Honor. Mr. Kelly is 39 years old. He states that he is employed by DMC Marketing. He is born and raised in Georgia and received his high school diploma and has some college education as well. We have no objection to him not returning to the location. This incident happened in 2021, and he has not been back, and there have been no other incidents involving my client or the alleged victim in this case. Mr. Kelly denies the allegations as alleged. And we are requesting a signature bond of $500. He already has a bond, a surety bond of $1,000. He is unable to make that bond. However, it's unlikely that given the other charges that Mr. Kelly has, as well as a potential probation violation, that he'll be released. But we would request a signature bond.
So you're saying at the present time, it's a $1,000 surety?
Yes, Your Honor.
Okay, I'm gonna leave it at the $1,000 surety. Stay away from the alleged victim, no further contact with the alleged victim. Stay away from the Marietta Boulevard address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Kelly.
Position number 7, Mr. Bowman.
Good afternoon, Mr. Poe. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Is that a yes?
Yes, Your Honor, good afternoon.
Good afternoon. Thank you, sir. Let's see. You've been charged in case 23 CR 002088F with criminal trespass. Is there a history?
36 total. Yeah, 36. Last arrest was 2021. Theft by receiver. That's open in state court. 21 CR 003-335F. Before that was 2016 misdemeanor possession of marijuana arrest. 2015 simple battery obstruction conviction. 2015 marijuana. We got another marijuana before that, 2014. And another one. 2013 trespass arrest. We got a lot of marijuana.
Okay.
Your Honor.
Bickerstaff?
Yes, Your Honor, this incident happened yesterday morning at about 12:42 in the morning at the BP gas station addressed at 464 Windsor Street Southwest. And this is where officers arrived to the gas station just to see the defendant outside of the gas station arguing with the on-duty security guard. The officer intervened and told the defendant that he had been recently issued a trespassing warning from that exact officer just 3 days ago, and that he needed to leave the BP premises. And so the defendant replied to the officer, "F you," and he walked to a neighboring sidewalk, and then he returned back to the property and said, "I'm not leaving, take me to jail." And so for these reasons, the state's recommendation is a $1,000 surety bond and to stay away from the BP gas station addressed at 464 Windsor Street Southwest. It's all from the state.
Thank you. Ms. Kim?
Yes, Your Honor. Mr. Pugh is 42 years old. He was born and raised here in Georgia. He actually works at Staff Zone. He's been working there for 5 years. And he completed up to 12th grade, but he did not graduate from high school, but he finished with a GED. Your Honor, even though he works, his income is not high enough, so he's qualified for public defender services. And also he's residentially challenged at this point. So we are actually sending out social worker to provide him housing resources. We would like to request for a signature on bond since he does not have any financial means to make a bond, and he does not have anybody else who can bail him out as well. So we would like to request for a signature on bond. Thank you.
Can you unmute courtroom 2, please? Mr. Poe, you know you can't go back to that BP gas station. You understand that?
Yes, Your Honor.
Okay, so if you go back to that BP gas station, you're gonna be right back here where you are, because they don't want you there, okay?
Yes, Your Honor.
All right, so I'm gonna give you the opportunity to get out and come back and answer these charges, but I don't want you going back to the BP, okay?
Yes, Your Honor.
All right, so it's gonna be a $2,000 signature bond through the jail. Stay away from the BP gas station on Windsor Street, and no drugs, alcohol, weapons while out on bond. I'm also want him to have a social worker visit so we can assist him with housing, okay?
Yes.
All right, good luck to you, Mr. Poe.
Your Honor, position number 10, Mr. Sterling.
Okay. Good afternoon, Mr. Sterling. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Sterling, you've been charged in case 23 CR 002090G with theft by taking. Is there a history, Mr. Howard?
Yeah, 16 total. Last arrest was back in February, probation violation. On probation for battery DV. He got put on probation for that back in February. 23 CR 000363G. It came off of January battery DV. He got fade to appear back in January as well. 2019 fade to appear. That one was dismissed. Another fade to appear for DUI. That's safe. Simple battery conviction 2019. 2016 DUI. Misdemeanor possession of marijuana conviction. Obstruction, no load. That was from 2016. 2016 probation, 2014 probation, and another 2014 probation. That's it.
Ms. Bickerstaff?
Yes, so Your Honor, this incident occurred July 17th, 2022. And this is where officers spoke with Miss Angela Williamson, who called the police just to make sure that the defendant did not damage any of her property while the defendant was gathering his belongings to leave the address of 4001 Lakemont Drive in College Park. And so, Your Honor, Williamson told the officer that the defendant had a history of damaging her things when they got into verbal disputes with one another. And so after the defendant and the police left, Ms. Williamson noticed that her iPad was missing. So she asked the defendant whether he took it or not. He stated he didn't. So then the next day in text messages, the defendant admitted to Ms. Williamson that he did in fact take her iPad and told her that she could come pick it up at his residence. And then then the defendant started sending Ms. Williamson some insulting text messages. And then he said that he didn't take the iPad, Your Honor. But for these reasons, the state's recommendation is a $1,000 surety bond, and we're asking for the defendant to stay away from 4001 Lakemont Drive in College Park, as well as no alcohol, drugs, or weapons while out on bond.
Yes, Your Honor. I believe that they have a wrong Mr. Sterling. I represented him on January 22, 2023 for another charge that he was here. So he was first arrested on January 17 at College Park, transferred to Fulton, and then he was transferred back to Fayette County. He's been in jail from January 17 until today, almost 3 months. And this never came up for his charge as his charge. He could not get out of the jail after he took care of all the issues at College Park, Fulton County, and Fayette County, because this came up. But if you see the citation, it has a different first name. My client's name is Antoine, and there is another person's name that is, I just had a
Antonio.
Yeah, my client is a 6'2", and the citation is for 5'8". They have a different driver's license number, different first name, and it's totally different person. I think they made a mistake to bring him back for somebody else. So we would like to request for signature on bond. He's been transferring back and forth from different jails, and I think he has been in the jail more than enough for theft by taking, Your Honor.
Your Honor, I'm not sure if this is the wrong defendant. In the warrant, it does say that the Fed police did arrest and hold Antoine Sterling into custody, and then they saw that they made a mistake and immediately released that guy, the wrong suspect. And it says on my end that this guy has been in like Fulton County Jail for the last 2 days. So I would believe that this is the correct suspect in this case, Your Honor.
The date of birth for the citation is October 15, 1992. My client's birthday is September 20, 1993. They have a different driver's license number. And Your Honor, my client is a whole lot bigger. It's very obvious. 5'8" and 6'2" are a huge difference.
Okay, I'll let you all work that out at some different time. I'm going to give him a signature bond through the jail, $1,000 signature bond through the jail. No further contact with Ms. Williamson. Stay away from the Lakemont Drive address, and no drugs, alcohol, or weapons while out on bond. So I'm going to allow you to get out, Mr. Sterling, and Ms. Kim can help you resolve this in the hopefully in the near future.
Your Honor, just for information purposes, page 15 of the police report in this case indicates that there was a clerical error on the citation, and then a warrant after this case was incorrectly documented, was obtained for the correct person after the fact. So there was an identity issue, but it is addressed in the police report and corrected.
Okay, thank
Specifically
you.
to what Ms. Kim is talking about.
Okay, thank you. All right, good luck to you, Mr. Sterling.
Thank you. What was the bond again, Your Honor?
$1,000 signature bond through the jail.
All right, we have position number 11, Mr. Stitchcomb.
Okay. Good afternoon, Mr. Stitchcomb. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Stitchcomb, you've been charged in case 23 CR 002091C with simple battery. Is there a history? Mr. Howard?
7 total. 2018 possession of marijuana. 2013 terroristic threats, reckless conduct, possession of a knife or a firearm during the commission. That's all I got.
Ms. Bickerstaff?
Yes, so this incident occurred yesterday at 1412 Epworth Street. That's EPWORTH. And this is where officers responded to that location and spoke with Miss Norisha Woods, who explained that she was in a verbal altercation with the defendant, who then proceeded to punch her in the back of the head. And so when officers spoke with the defendant, he denied hitting Miss Woods, but he did admit that there was a verbal dispute. The officers observed the defendant at the time repeating himself and having slurred speech. And when asked did he have anything to drink that day, he did admit to having 2 beers. For these reasons, the state's recommendation is a $3,000 surety bond, 1-day anger awareness, no further contact with Miss Norisha Woods. Norisha is spelled Norisha, and no alcohol, drugs, or weapons while out on bond. The state's not asking for a stay away at that address because I believe that that is his residence, Your Honor.
Ms. Kim?
Yes, Your Honor. My client, Mr. Stitchcomb, does not have any objection to stay away. I mean, not stay away. No further contact with Norisha Woods. They don't have any relationships. They don't live together. They're not. They don't care for each other, I guess. My client clearly denies the allegation. He is 56 years old. He was born here in Georgia. After he being widowed, he's been single, and until 8th grade, he went to school. After that, that was it. And right now, he does not have any employment. So he's qualified for public defender services, and we will continuously represent him even after this bond hearing, Your Honor. We would like to request for a signature on bond, since this is, he did not do it, Your Honor. Thanks.
All right, it's a $2,000 signature bond through the jail, no further contact with Ms. Woods, and no drugs, alcohol, or weapons while out on bond.
Okay.
Good luck to you, Mr. Stitchcomb.
Thank you.
You're welcome.
Your Honor, we have one more time, it's position number 4, Ms. Gilmore.
I'm sorry, say it one more time.
Ms. Gilmore, position number 4.
Okay, Mr. Howard, were you able to speak with Ms. Gilmore?
I spoke with him on the phone. He stated that he was. He also stated he was still at the jail with her.
He just stepped out for a brief second, Your Honor.
Say it again.
Here you come right now, Your Honor. Yes, signature bond. And Mr. Y'all, you said Mr. Stitchcomb has 2.5 signature bond in jail or that pretrial?
It's a $2,000 signature bond through the jail.
We done, right?
Not quite. Mr. Howard, how do you want to handle this?
Judge, I've had a good conversation with Ms. Gilmore. We discussed, the state of things, where she is now and where we're trying to go. She did express, after our conversation, a willingness to consent to go to the facility that Ms. Stevens was recommending. So we would ask, I guess, once we have the details of what that would look like, we would ask court to sign an order for her to be released to whoever would be responsible for the transport. But she was, she's willing to do that. She understands that there's some things that are going to need to be consistent going forward, and we've talked about that as it relates to medication compliance. She wants to finish school. It's one of the first things she really impressed upon me. She really is concerned about being able to finish her education. She expressed to me that she needs therapy and said that she's asked for that at the last placement that she was at. And I would agree, given what I've heard, that certainly whatever plan is put in place going forward, that would need to be a big part of that. I think that'll help her to begin to be able to navigate through some of the challenges that she's had. So Judge, we would ask the court sign a release order. Once we have the details, we'll certainly provide that order, but for someone to pick her up and for her to be transported to that hospital. And then we will also try to work on a support system for when she's done to see what housing options might be available after that. We certainly are willing to do whatever we can to try to assist in that as well.
Okay. Any objection from the state?
No objection.
Okay, and if you'll send them the order also, Mr. Howard, before you send it to us, just so Ms. Bicker's staff can look it over, and then we'll get it signed, okay?
Absolutely. And Ms. Wills, did you hear back from Ms. Stevens or?
Yes, Ms. Scott from Clayton County DFACS is on the line. And so Ms. Scott, would you all be able to arrange a behavioral aid to pick Ms. Gilmore up from the jail? I'm sorry, it appears you froze for a little bit.
I'm sorry, can you hear me?
Yes.
Yes.
Oh, I do apologize. Yes, we would be able to arrange for a behavioral aid.
Okay.
And so what we'll need is just the name of who that person would be, a contact number for him or her, and then when the anticipated time that they will be able to come pick her up so that we could prepare an order for the judge to sign for her to be released to that person.
Okay.
So let me get some clear understanding on this. This was a status update. So when are we gonna reset her? Or is she going back to the original judge, or Judge Morrow, is she still coming back to you on next week?
I'm hoping that they can, how quickly do you think you can get this this order together, Mr.
Judge.
Mr. Howard, excuse me.
It really, so as we can get the information from Ms. Scott, we can send the court the order like,
Okay.
like we do.
So she doesn't need to be reset, is what I'm asking.
Not for that purpose, no, Judge.
Okay.
Okay. So I'm just gonna mark my record as a status update then. And then we'll get the order from you all, and then we'll make it a part of the file. Is that proper, or?
Sure, and we can put it, Judge, if, I don't know, we can put it on another day that Your Honor's on, just to make sure that she's released and everything goes as it should, just to sort of make sure that things happen like we thought they would, but, you know, whenever that will be convened is fine.
Okay, we just want to put it on for Monday. Everything should be able to resolve by Monday, and I'm on the this calendar on Monday. So let's just put it back. I think that's 4/10.
It is.
Thank you.
Okay, very good. All right, I'm glad that you were able to work that out. We appreciate it. Good luck to Ms. Gilmore.
Thank you. Thank you, Judge.
You're welcome.
So
All
with
right.
that being said, are we ready to go with the calendar now?
I believe so. Thank you.
Okay. Once again, the reset date for the SAP calendar is going to be April the 20th. Position number 1 is reset further notice with a $2,000 SOB through the jail. Position 2 is reset further notice also with a $2,000 SOB through the jail. Position 3 is reset further notice with a total $3,000 SOB through pretrial per judge. Position 4 is going to be reset to the C calendar for Monday with the status update. Position 5, reset further notice with a total $3,000 SOB through the jail. Position 6, reset to the SAP calendar with a $1,000 good bond. Position 7, reset further notice with a $2,000 SOB through the jail. Position 8, reset further notice with a $2,000 SOB through the jail. Position 9, reset further notice with a $2,000 SOB through the jail. Position 10, reset further notice with a $1,000 SOB through the jail. Position 11, reset further notice with a $2,000 SOB through the jail. And position 12, reset further notice with a $3,000 SOB through pretrial per judge. Are there any questions, comments, corrections? No?
Okay. If not, thank you all. I really appreciate you all today. I know that sometimes these calendars can be particularly difficult, and I think that today was one of those days, but I appreciate everyone working together and, you know, for the best resolution and the best outcome for everybody involved. So I acknowledge how hard you all are working, and I appreciate you all working with the court in that regard. So thank you very much. It's a pleasure working with you all. So I'll see you next time. Okay.
Bye. Thank you.
Thank you, Judge.
Okay, bye-bye.
Let's have a great weekend.
Oh, for those who are no longer here for the rest of the week, happy Easter.
Happy Easter.
Thank you.
Happy Easter. All right. You too, Miss Big Brother.
Thank you.